Hi, my name is Luke Newman, and I'm a criminal defense lawyer in Tallahassee, Florida. I'm a board-certified specialist in criminal appeals. I wanted to talk to you today about an issue that's commonly misunderstood, and it's a source of confusion in criminal practice, both in Florida and throughout the country. I'm often contacted by a potential client or in a discussion with a current client and asked whether or not a case can be thrown out of court because the police failed to read my client his rights or her rights. What that comes from, the reading your rights language, is a decision from the United States Supreme Court in Miranda versus Arizona. What the court held in Miranda was that the defendant who made statements in response to a police interrogation had to be informed of his right to remain silent and his right to an attorney, and had to have waived those rights prior to the government putting the defendant's statements into evidence at a criminal trial. So what Miranda requires is two elements, namely custody and interrogation. The first element, the element of custody, requires the defendant not be physically free to leave. So in order for Miranda to apply, an individual must be restrained from physically leaving the location in which he's being questioned. What this requires is generally handcuffs, being locked in the back of a police car, being in a cell, being formally placed under arrest, or things of that nature. Simple police contact or communication that occurs outside of that setting does not trigger the custody element of Miranda, and therefore no warnings must be given, and a defendant's statements can be entered into evidence by the government. So situations arise in which people make statements to police officers who have arrived at their front door and knocked on their front door and conducted a conversation. Miranda is not required in those situations. Similar situations come up when students, for instance, are summoned to the principal's office and are asked about criminal activity and make statements. A student even being told that he or she would have to go to the principal's office and speak to the principal is not in custody for Miranda purposes. Police officers will often meet suspects at a place that's not a police location, for instance at a restaurant or at their homes, and will conduct a conversation. Those conversations in those settings do not implicate the custody element of Miranda, and no warnings are required to be given at that point. Now, what frequently comes up is people talk to me about they were stopped in a traffic stop, and they had a conversation with a police officer on the side of the road while they were being detained pursuant to a traffic stop. What the United States Supreme Court has said about that is that individuals detained during a routine traffic stop are not in custody for Miranda purposes. Now, sometimes I'll be asked about individuals who've been requested to step out of the car to speak with police officers. The Florida courts are split on that, but there is Florida case law that suggests that people who are simply asked to step out of a car are not in custody for Miranda purposes. One thing that comes up in Florida often is Florida's statutory accident report privilege. In Florida, those involved in a traffic crash are required to make a report that's compiled by the Department of Highway Safety and Motor Vehicles for accident report purposes in highway safety. Now, because Floridians and those traveling in Florida are required to make such a report, what they say in making that report cannot be used against them. So what you'll see oftentimes in a criminal case that begins with a traffic accident is the reading of Miranda, which is done by law enforcement in order to show that the traffic crash investigation has concluded and that a criminal investigation is now underfoot. The next element that requires a Miranda warning and a waiver is interrogation. Interrogation can be either express questions, meaning questions that if they were written out on a piece of paper would end with a question mark, or it can be what's described as a functional equivalent. Now, the functional equivalent has been held by U.S. Supreme Court to be a pretty tough standard to meet. In one case, there was a defendant who was arrested. He was incarcerated in the back of a police car, and police officers were having conversation in the front seat of the police car, and were going back and forth about a firearm that they believed the defendant had tossed in the neighborhood, and maybe, depending on who you talk to intentionally, had a conversation about what a shame it would be if the firearm were recovered by a child in the neighborhood and resulted in an accident or the use of the firearm by a child, the defendant in the back seat spontaneously came forward to the police officers and explained to them where the firearm was located. And this case went all the way to the United States Supreme Court, which eventually decided that the police officer's conversation in the front seat was not actual interrogation. There are exceptions to the Miranda requirement. There are circumstances in which an individual's statements can be admitted at a trial if the individual was not warned and the individual did not waive his Miranda rights, even in cases where he was asked questions and while he was in custody. The most common of these exceptions is what's called the booking question exception. When an individual is being booked into the jail, he or she is regularly asked for his address, his date of birth, his height. Those questions, the common booking questions, are not subject to Miranda exclusion. Additionally, you'll sometimes read about what's called an emergency exception or a public safety exception to the Miranda requirement. This is invoked by the state when there is a public safety concern on the part of the police. They are allowed to ask questions of people who are incarcerated and use those answers in order to create state evidence at a trial. You've heard about this probably in relation to the Boston Marathon bombings, but there are other cases in which are not as well known in which this exception has been invoked. So what will courts do when they're confronted with situations in which Miranda has been violated? Oftentimes I'm asked whether or not the case will simply be thrown out or dismissed. This would not be an appropriate remedy. What courts will do in a situation in which a statement has been obtained in violation of Miranda is exclude the statement from the state's case in chief. That means that the state will not be allowed to introduce that statement when it's putting on evidence in an attempt to convict the defendant initially. What it will not do is invoke the fruit of the poisonous tree doctrine and prevent any other evidence that was obtained in reliance on that statement from being entered. What it also will not do is protect the defendant who then testifies in his or her own defense from being impeached with those statements. A violation of Miranda simply prevents the state from using that statement when it's putting on evidence in an attempt to convict the defendant initially. It doesn't prevent the statement from being used for derivative purposes. We've talked about custody, interrogation, exceptions, and remedies. I think that the confusion surrounding Miranda comes from the fact that it gets read on television all the time, both in reality shows and in dramas as well. Make no mistake, if you hear Miranda warnings being read to you by a law enforcement officer, my advice is that you contact your criminal defense lawyer immediately. But on the other hand, just because you didn't hear a Miranda warning, don't believe that what you're saying or what you have said cannot be used against you in court.